Let's take a look at an essay in the area of business associations and see what issues we can spot in these facts. If you're a user of our Power Law program or Proponics, that are unfolding schemas, the software system we developed where you can unfold the law that you need to memorize for the bar exam, you'll notice that we've divided this into 3 separate schemas. We have one for agency, one for partnership, and one for corporations. A lot of the law that you will need to analyze in an essay depends on what entity you find was formed. So let's take a look at this one and see what we've got. We have 3 calls. The first one says, how should ABC's debt be allocated? Allocation of debt. That probably means we have an entity that's not a corporation. Otherwise, they wouldn't be asking us about debt allocation rules. The second call says, is DECO likely to succeed in its lawsuit against ABC? Well, you know, that could be quite a few things, including a promoter, and they're asking about liability, or it could be a contract or a tort entered into by one of the partners or members of the corporation. Third call, is Zeta likely to succeed in its lawsuit against ABC? Well, when we have 2 different calls that involve lawsuits against a business entity, most often one of them is a tort and one of them is a contract. But we'll see what comes up in these facts. Okay, go to the top, and we see that Alfred, Beth, and Charles, there's our ABC, orally agreed to start ABC Computers, a business to manufacture and sell computers. And what we know right away is that they have at least a partnership, a general partnership, right? Because that simply requires contract capacity, the intent to go into a business for profit, and some sort of legal purpose for the business. Manufacturing and selling computers is a legal purpose. So at the very least, we have a general partnership here. It goes on to say Alfred contributed $100,000 to ABC. That $100,000 is a capital contribution, and we're going to need to keep that in mind when we talk about how the debt should be allocated, because if this entity dissolves, and it must be going to, or they wouldn't be asking how should the debt be allocated, then that capital account is part of the entity's debt. Stating to Beth and Charles that he wanted to limit his liability to that amount. How do you do that? In a general partnership, all the partners are equally liable. They have joint and several liability. Okay, if you want to limit your liability in an entity, then you're trying to form a limited partnership where at least one of the partners has limited liability and at least one is a general partner. Beth, who had technical expertise, contributed $50,000 to ABC. There's another capital contribution, another capital account. So we have Alfred with a capital account of $100,000, Beth with a capital account of $50,000. That means that we have $150,000 at this point in debt for this business, for this partnership, whatever it winds up being. Charles contributed no money to ABC, but agreed to act as salesperson. So that does not add to the debt. And in a general partnership, or any kind of a partnership really, they don't have to contribute equal amounts. So that's just fine. Alfred, Beth, and Charles agreed that Beth would be responsible for designing the computers and that Charles alone would handle all computer sales. So there they are trying by agreement to limit authority. Charles alone has the authority to handle sales. The other two do not have authority. And unless we get more facts, what we have here is a general partnership. Charles and Alfred and Beth are general partners. Now, Alfred wanted to limit his liability, but he cannot do that without notifying the public, essentially. And that's what we mean when we say that limited partnerships and limited liability partnerships can only be formed by formalities, by filing the proper documentation with the Secretary of State, because that puts the public on notice that at least one of those partners has limited their liability. Without those formalities, this is simply a general partnership. We see that ABC opened and quickly became successful, primarily due to Charles' effective sales techniques. Subsequently, without the knowledge or consent of Alfred or Charles, Beth entered into a written sales contract in ABC's name with Deco Inc. to sell computers, manufactured by ABC at a price that was extremely favorable to Deco. Does she have the authority to do that? Well, not express authority, but we'll come back to that. Beth's sister owned Deco. They are setting up for us a breach of the duty of loyalty here. They're setting up for us that there's a personal gain here, that this action isn't being taken primarily to benefit the company. It may be a violation of due care. It's apparently certainly a violation of the duty of loyalty. When Alfred and Charles became aware of the contract, they contacted Deco and informed it that Beth had no authority to enter into sales contracts and that ABC could not profitably sell computers at the price agreed to by Beth, which gives us what we need to argue that this was a breach of the duty of due care. ABC refused to deliver the computers, and Deco sued ABC for breach of contract. So we have one of the three partners who did not have the express authority to do so, entering into a contract that would not only not be profitable, but would probably harm the company. And we have the other two partners attempting to convince Deco that there was no contract. Deco sues for breach of contract. That goes to call 2. Is Deco likely to succeed in its lawsuit against ABC? Well, the issue here is whether Beth had the authority to enter into this contract. In order for Deco to succeed, they are going to have to establish that Beth had the authority to enter into the contract, and so it's a valid contract. We know that there are two kinds of authority for partners: actual authority and apparent authority. Beth did not have actual authority. She was an agent of the partnership. That authority to enter into contracts, that actual authority, had been limited by agreement among the partners to Charles alone. So Deco is going to have to rely on the theory that Beth had apparent authority, and I think they'll prevail in that. ABC did not notify third parties that they had limited the usual authority of any of the partners. So in essence, they held out all the partners as having the authority to enter into these contracts. I would also say in my answer that partners are jointly and severally liable for this breach, for the damages associated with this breach, but that partnership funds will be primarily liable. If there are no partnership funds, then the partners are jointly and severally personally liable for the debt from this breach. And that's because Alfred failed to limit his liability by forming a limited partnership, and what we have here is a general partnership. But I'm not done yet with this call, because that ordinary rule of joint and several personal liability, if the partnership doesn't have sufficient funds, is going to be changed by the fact that Beth breached the duties of due care and loyalty, which means that the partners will be able to go after her for those breaches, and she will wind up paying for the damages from this breach of contract, or at least some of them. She will have increased liability because of those breaches of fiduciary duty. So I would analyze the duty of due care and the duty of loyalty. And yeah, that benefit goes to her sister, but it's to a family member, so you have to view that as a breach of the duty of loyalty, that she's deriving a personal benefit because she's benefiting her family. The partnership itself could go after her for breaches of due care and loyalty. We don't yet know what the partnership has at the time it dissolves. That's yet to come in the facts, but they never give us enough funds to pay off all the debts. There's always going to be an issue of how those debts are allocated, which is what Call 1 is. So we'll get there as we move forward in the facts. And I think the other thing I want to tell the grader about the breach of the duty of due care is that it doesn't go to ordinary business decisions that happen to turn out badly. Breach of the duty of due care requires some sort of gross misconduct, some sort of reckless conduct, gross negligence, intentional misconduct, which is what happened here. So we go on to see that thereafter, Alfred became concerned about how Beth and Charles were managing ABC. He contacted Zeta, ABC's component supplier. He told Zeta's president, "Don't allow Charles to order components. He's not our technical person. That's Beth's job." What do I do with that? Can Alfred do that? Well, look back at the agreement to form this partnership. The only limitation on authority there is that Charles alone would handle computer sales. It says that Beth is responsible for designing the computers, but it doesn't say that anybody else is limited in any way. So Alfred and Beth are limited in their authority to sell computers. Other than that, these three partners have all the usual authority to conduct business, which means the authority to buy supplies, to buy what's necessary to carry out their business. One partner cannot unilaterally limit the other partner's authority. That would have to be done by agreement among all the partners. And next we see that Charles later placed an order for several expensive components with Zeta. ABC refused to pay for the components, and Zeta sued ABC for breach of contract. That's Call 3. Can Zeta prevail in a lawsuit against ABC for breach of contract? Well, to prevail, they have to prove that Charles had the authority. And as I said, that's within the usual authority of a partner, and it was not limited in any way. Alfred's effort to limit Charles's authority fails, and so Zeta would prevail because they could prove that Charles had the authority and that that contract was binding. But notice what else I need to use those facts for. We said earlier on that a general partnership was formed, that Alfred did not successfully limit his liability because the proper paperwork was not filed, the formalities were not filed to form a limited partnership. But even if they had been, at the point that Alfred intervenes here and tries to make a management decision, he would have destroyed his limited liability status, because a limited partner cannot participate in management functions. So even if an LP, a limited partnership, had formed, Alfred would still be fully, jointly, and severally liable because he would have destroyed the limitations to his liability. That's an important point to raise to get more points on this essay. And now we see that not long afterwards, ABC went out of business, owing its creditors over $500,000. Now we have what we need to analyze call 1. How should ABC's debt be allocated? When we dissolve a general partnership, the way it works is that all creditors are paid, including creditor partners, first. Outside creditors are paid before inside creditors. Then we pay off the positive balances in partners' accounts. In other words, the capital contribution at the creation of the partnership. It's credited and charged throughout the partnership. And if there are negative balances, then each partner must deposit proportionally the funds that are necessary to cover the debt. Now, they don't tell us whether the partnership had any funds at dissolution. They just tell us that it owed creditors over $500,000. So I would tell the grader that partnership funds would be used to pay off as much of the debt as there were funds available, starting with the outside creditors, and that then the remaining debt, including the $150,000 in capital accounts, would be allocated to the 3 partners equally, and they would be required to pay their third personally.